Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court in special sitting took suo motu cognizance of an unusual order of the Allahabad High Court asking the head of the Department of Astrology of Lucknow University to decide whether a woman, an alleged rape victim, is Manglik or not. The vacation bench comprising of Justice Sudhanshu Dhulia and Justice Pankaj Mittal held in a special sitting to stay the order and observed that it doesn't understand why the astrology report is called for while hearing a bail application. The High Court had passed the order while hearing the bail petition of the man accused of raping the woman on the false promise of marriage. His counsel had argued before the High Court that since the woman was a Manglik, marriage between the two could not be solemnized and has been refused. This was refuted by the victim's side. According to Hindu astrology, a person born under the influence of the planet Mars, Mangal, is believed to have Mangal dosha, affliction, and is called Manglik. Many superstitions Hindu believe that marriage between a Manglik and a non-Manglik is inauspicious and can be disastrous. Appearing in the matter, Solicitor General Tushar Mehta called the order disturbing and asked the court to stay it. The court noted that even though the order was passed with consent, it was still bad in the eyes of law. The Supreme Court has observed that under Section 319 of the Criminal Procedure Code, a court holding a trial to proceed against any person not mentioned as an accused in the FIR but has committed a crime ought to be tried together with the accused who is facing the trial. The division bench of Justice Dipankar Datta and Justice Pankaj Mittal also noted that the court holding the trial must be satisfied beyond a reasonable doubt as formed at the stage of a charge being framed. The court observed that Section 319 of the CrPC empowers the court holding the trial to proceed against any person who is not shown or mentioned as an accused in the FIR but appears from evidence beyond reasonable doubt to have committed a crime ought to be tried together with the accused facing the trial. The Supreme Court has observed that it is the duty and obligation of the criminal court to exercise a great deal of caution in issuing process, particularly when matters are of civil nature. In case where it was contended that the agreement in question was void ab initio, as a person belonging to a scheduled caste could not transfer property to any person not of a scheduled caste without prior permission from the relevant authorities, and the FIR lodged was 4 years after the slated date of the execution of the deed, and that the present agreement to sell was forged, the court noted that no terms reflect the dispute as being a civil nature. It took into reference Sarabjit Kaur versus the state of Punjab and others and stated that a breach of contract does not give rise to criminal prosecution for cheating unless the fraudulent or dishonest intention is shown right at the beginning of the transaction, and mere allegations of failure to keep up the promise would not be enough to initiate criminal proceedings. The court also mentioned ARCI versus Nimra Surglass Techniques Limited and noted that while deliberating upon the difference between mere breach of contract and the offence of cheating, the distinction depends upon the intention of the accused at the time of the alleged incident. Hence, criminal liability would be attached if dishonest intention on part of the accused can be established at the time of the entering into the transaction. The court ascertained that the dispute was entirely with respect to the property and more particularly buying and selling thereof. It could not be doubted that a criminal hue has been unjustifiably lent to a civil natured issue. The Supreme Court has held that even though an agreement to sell may not be regarded as a transaction of sale, but the prospective purchaser, having performed his part of the contract, acquires possessory title over the property. Furthermore, such possession can be invaded by the transferor, hence entitling the owner right for an eviction decree with mensne profits. The court observed that although an agreement to sell was not a document of title or a deed of transfer of property by sale, and as such may not confer absolute title upon the plaintiff respondent over the property by virtue of Section 54 of the Transfer of Properties Act 1882, but the agreement to sell, the payment of entire sale consideration is mentioned in the agreement itself and corroborated by the receipt of its payment, and the fact that the plaintiff respondent was put in possession of the suit property established by the possession memo on record proved that the plaintiff respondent was de facto having possessory rights over the suit property, and such possession could not be disturbed by the transferor. The Supreme Court has held that the power of attorney executed is of no consequence if neither sale deed has been executed nor any action pursuant thereof has been taken by the power of attorney holder. The division bench of Justice Dipankar Datta and Justice Pankaj Mittal observed that the power of attorney executed by the defendant has no bearing because neither a sale deed nor any other action done by the power of attorney holder in accordance with it has been executed which may have conferred title on the plaintiff respondent. The specified general power of attorney is rendered ineffective if any document is not executed by the person holding it as a result. It was furthermore observed that the will executed has no meaning as the same comes into effect only after the death of the executant and not before it. It was noted that the general power of attorney and the will was executed as well as any practice followed by a state or the High Court that recognizes these documents as being documents of the title or documents granting rights in any immovable property violate the law. Next we have Delhi High Court. The Delhi High Court has propounded that filing a petition under Section 482 of the Criminal Procedure Code in the guise of a Second Revision Petition is not maintainable. It was clarified that a person who has already chosen to file a revision either before the High Court or the Sessions Court is precluded from approaching the other court. However, the High Court may entertain the revision if the Sessions Judge has reserved the order of the lower court. But this is not an automatic right for every aggrieved party. It was also opined that although Section 482 of the CrPC allows the High Court to exercise its power to prevent abuse of process or secure the entire ends of justice, the court would generally discourage filing a second revision petition when the petitioner has already availed the remedy of the first revision in the Sessions Court. The Delhi High Court has ruled that when a born ossification test indicates an age range for a child victim under the Protection of Children from Sexual Offences Act, the court must lean towards considering the lower side within the margin of error during age determination. It was emphasized that the intention behind the enactment of this act is to provide the utmost protection and support to minor victims of sexual offences. It was expounded that according to Section 29 of the POCSO Act, there is presumption of guilt against the accused and it is the responsibility of the prosecution to present foundational facts indicating the commission of the offence by the accused. Once this is established, it is up to the accused to refute the presumption of guilt. The court opined that in determining the age of a child victim under the POCSO Act, when the born ossification test indicates an age between 15 to 17 years, the court should lean towards considering the lower side within the margin of error. The interpretation aligns with the objectives of the POCSO Act. It cannot be the intention of the POCSO Act to treat a borderline minor victim as an adult in cases where there is no birth certificate or school certificate as a born ossification test has been conducted. Such an interpretation would be contradictory to the objectives and purpose of the POCSO Act. The bench held that the statement of the prosecutrix can be the sole basis for conviction unless there are valid reasons for the court to doubt its veracity or seek corroboration. The Delhi High Court has pronounced that the practice of filing fragmented charge sheets is in direct violation of Article 21 of the Constitution. The High Court highlighted a charge sheet should only be filed when the investigation related to the first information report is fully completed and a definite opinion has been formed regarding the alleged offence against the accused. The single judge bench of Justice Amit Sharma held that a charge sheet could only be filed when the investigation related to the FIR had been completed and an opinion had been formed regarding the alleged offence against the accused. It was ruled that the investigating agency was not allowed to fragmented or divided the FIR and file separate charge sheet. Doing so would violate the rights of the accused under Section 167(2) of the Criminal Procedure Code and Article 21 of the Indian Constitution. The Delhi High Court has opined that the copyright of a movie does not extend to encompass the copyright of its screenplay. The court highlighted that the definition of a cinematograph film as provided in Section 2F of the Copyrights Act 1957 includes elements such as the soundtrack but specifically excludes the screenplay. In the case germinating from disputed claim over the popular movie Nayak, the court opined that the assignment of the right to novelize the screenplay was done lawfully with the authorization of the rightful copyright holder. It stated that the Supreme Court had previously addressed the issue as to whether a creator of a musical work who granted a license or permission for its inclusion in the film's soundtrack could prevent the film from being publicly screened and had ruled that the creator could not prevent the screening but clarified that their right to commercially exploit the musical work remained intact. The Delhi High Court has upheld the validity of an order that mandated Delhi residency as a requirement for the recruitment of civil defense volunteers. The court further emphasized that the incursion of the residency condition was justified and did not violate constitutional rights under Article 14, 16 and 21. A writ petition was filed before the High Court challenging the constitutional validity of the order passed by the Secretary, Revenue and Divisional Commissioner, Revenue in the matter of the recruitment of civil defense volunteers. It was argued that the requirement of being a resident of Delhi was not specified in the Civil Defence Act 1968, Civil Defence Rules or the Civil Defence Regulations. Further, anyone can become a civil defence volunteer in Delhi. It was further contended that the Commissioner lacks the authority to issue such a circular as he is not the competent authority under the Civil Defence Regulation 1968. By limiting the recruitment process to Delhi residents only, the respondents were alleged to be infringing upon the fundamental rights guaranteed to all the citizens of the country. The Civil Defence Act was passed following the Chinese invasion of the country in 1962. The purpose was to minimize casualties, ensure the continuation of essential services and restore disrupted civil services by implementing civil defence measures in areas most vulnerable to enemy attacks. The Act mandates the establishment of civil defence services in the state and union territories. Now, let's have an overview of other high courts. The Jammu and Kashmir and Ladakh High Court, while granting bail to a petitioner involved in Protection of Children from Sexual Offences Act, observed that mere absence of the prosecutrix from court proceedings should not result in indefinite deferral of the bail petition. The court considered the fact of the case and observed that the petitioner is facing trial for offence under Section 8 of the POCSO Act and said that offences carries maximum punishment of imprisonment of 5 years. It paid reliance to Section 436A of the Code of the Criminal Procedure, which provides for maximum period for which an under trial prisoner can be detained, and expounded that it is clear that the under trial prisoner cannot be detained for a period more than one half of the maximum punishment period imprisonment specified in the offence in which he has been taken into custody, and upon expiry of the said period he has to be released by the court on personal bond with or without sureties. The Orissa High Court, while dealing with multiple writ petitions, disallowed the grant of an ad hoc promotion to government employees with pending criminal cases with or without exoneration in the departmental proceedings. The court observed that there is no right of the government servants to be considered for promotion during the pendency of either departmental proceedings or criminal proceedings, or both, against such government servant. It clarified that as and when the criminal proceedings are in favor of the government servant by way of acquittal, and such government servants also stands exonerated from the departmental proceedings, then notwithstanding the superannuation of such government servant, the national benefit attaching to the promotion that is due to the government servant would be calculated and the pension fixed accordingly. The Karnataka High Court has reiterated that atonement by the leasee is not necessary for the transfer of property leased out to him under Section 109 of the Transfers of Properties Act. The single judge bench of Justice Ashok S. Kingai in this view allowed the appeal filed by the plaintiff landlord seeking eviction of the defendant tenant and payment of arrears, rejecting the question on the status of the landlord tenant raised by the latter. The court noted that as per Section 8 of the Transfers of Properties Act, there is presumption that when the property is transferred, all things attached to the earth, such as trees and shrubs, are also transferred along with the land. The plaintiff became the owner of the operation of land on the strength of the registered sale deed. Such transfer will not affect the tenancy, as tenant will continue till the eviction of tenant by the procedure of law. Defendant does not acquire any interest in the property, as such tenant cannot challenge the right title of his landlord. The tenant remains as a tenant under the transfer or landlord, the court ruled. In a relief for a women's rights activist, Rehana Fatima, who was facing charges under Protection of Children from Sexual Offences Act case for allowing her children paint her semi-nude body, the Kerala High Court has ruled that her act cannot be characterized as a real or stimulated sexual act, and said that the society's default view that the naked upper body of the female is sexualized in all contexts is unfair and discriminatory. The right of a woman to make autonomous decisions about her body is at the very core of the fundamental right to equality and privacy. It also falls within the realm of personal liberty granted by Article 21 of the Constitution, the court said. Fatima was charged under POCSO and Juvenile Justice and Information Technology Acts for circulating a video in which her minor children were seen painting her semi-nude body. The court discharged the 33-year-old activist from the case, citing that it was harsh to term such an innocent artistic expression as a usage of child in a real and stimulated sexual act, and it did not amount to child pornography. Moving on to miscellaneous news. The Bar Council of India has entered into a memorandum of understanding with the Bar Council of England and Wales and Law Society of England and Wales for an exchange program of lawyers and law students for mutual exchange of training and learning amongst each other's jurisdiction. Under the MOU, the Bar Council of India has been authorized to recommend some young lawyers to the Law Society and to the Bar Council of England and Wales to provide opportunities of training and learning in international law firms, good law offices, and in English law courts. However, the lawyers recommended by the Bar Council of India shall have no right to practice in UK in terms of the MOU. The purpose is only to facilitate an opportunity of learning and gaining experience in both jurisdictions. In a similar manner, selected law students will be recommended by the BCI for undergoing internships to the bar bodies of UK. The MOU further provides for extending training facilities to the solicitors and barristers of England and Wales. Such trainee solicitors and barristers shall not be allowed to practice in India in any form under the terms of the MOU, and that 90 days program shall only be confined to training and learning only. Major lawyers bodies in the National Capital of Delhi, including the Bar Council of Delhi and the Delhi High Court Bar Association, has sought a stay on the recently issued Bar Council of India rules, which allows the entry of foreign lawyers and law firms to practice foreign laws in India on a reciprocity basis. BCD had constituted a special committee on March 20th, 2023 for consideration of the new BCI rules. Upon deliberation, the committee unanimously concluded that the rules will have serious repercussions and far-reaching effects on the legal profession in India. It also pointed out that the Bar Council of India issued the rules without taking the entire legal fraternity across the country into confidence, stating that the rules will substantially damage the legal profession and jeopardize the interest of all Indian advocates. The members resolved that all bar associations will hold meetings to apprise their members about the rules and their consequences. It has also been resolved that all bar associations will hold meetings to apprise their members about the rules and its consequences. In the latest case against car manufacturers in Consumer Court, the Chhattisgarh Forum has asked Ford India Private Limited to pay to Rs 29 lakh as a compensation along with the brand new Ford Endeavour to a customer who was sold a car with issues. The owner of the Ford Endeavour had bought the SUV almost 7 years ago and has been facing issues with the vehicle ever since. The Ford Endeavour has the flagship SUV from the Ford in the Indian market. The Consumer Dispute Redressal Commission has now asked the dealer to hand over a new vehicle for the same model manufactured recently to the customer. Additionally, they must pay a compensation of which the purchase price of the vehicle along with 6% interest for last 7 years. The court had also instructed them to pay damages to the customer for mental agony and physical agony as well as the cost of litigation. The All India Bar Association has called for changes in the manner in which judges are elected to the Supreme Court and High Court, saying their appointments and elevations should be made solely on basis of merits. Adish C. Agarwal, the chairman of the AIBA, while speaking to the media, also said that the court proceedings should ideally be video recorded and that the retirement age of the judges in the Supreme Court, High Court and the subordinate judiciary should be raised. He also said that the retired judges should not be appointed by any tribunal or commissions. On the issues of the appointment of judges to High Courts, Agarwal was also against Chief Justices of the High Court being chosen from the High Courts of the other states. In the end, we have international news. Ukraine and Russia are scheduled to face off the International Court of Justice, the top United Nations court, over Moscow's support for pro-Russian forces blamed for insurrection against the Ukrainian state and armed violence that includes the shooting down of the Malaysian airline flight MH17 in 2014, killing all 298 passengers and crew. Judges at the ICJ in The Hague will hear Ukraine's claim that the Moscow violated a UN anti-terrorism treaty by equipping and funding pro-Russian separatists who international investigators concluded, has used a Russian missile to shoot down the Malaysian jetliner over eastern Ukraine almost 10 years ago. Prince Harry has given evidence at the High Court in London in his lawsuit against the publisher of the British tabloid Daily Mirror, which he accuses of phone hacking and other unlawful acts. Mirror Group newspaper, the publisher of the Daily Mirror, Sunday Mirror and Sunday People, has previously admitted its titles were involved in phone hacking but said that there was no evidence that Harry had been a victim. A Japanese court has said that a ban on same-sex marriage was unconstitutional but raised concern about the dignity and human rights of the same-sex couples, a ruling short of activists' expectation but still seen as a step forward. The ruling by the Fukuoka District Court came a week after another district court said it was unconstitutional to ban same-sex marriage, bolstering hopes of the change among the LGBTQ community in Japan, the only group of the 7 nations without legal protection for same-sex unions. 5 rulings on the same-sex marriage have been handed down in Japan over the past 2 years. 2 concluded the ban was unconstitutional, 1 saying it was not, and 2, including this, upholding the ban but raising other rights concern. A Tokyo court last year upheld the ban but said that a lack of legal protection for same-sex families violated the rights. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.